Hello, my name is Nicole Needham, and I just graduated with my Master's of Science in Clinical Mental Health Counseling, and I am currently going through the process to study for the Oklahoma Legal and Ethical Responsibilities exam, or the OLERE, and also the NCE National Counseling exam. So I am an educator in my current job. I travel and teach, and I find that sometimes the best way I learn is by teaching. So I thought I would just record this mainly for myself to review the OLERE, but then some other people have asked if they could hear it if I did it. So I am going to put this on YouTube, and then if it ends up being something that can help other people, that is great. So I wasn't really even prepared to do this. This is a PowerPoint slide that Notebook LM made, and I'm gonna sort of follow this, so I thought it was a good informative one for you guys to look at. Anyway, I'm just gonna go over some of the more important things. This is a 60-page document, the unofficial rules for LPCs to know, and there's a lot of information in there, so I'm gonna just kind of go over some of the key points and then just skim some of the things at the end. So the first thing is that we are going to receive our license through the Oklahoma State Board of Behavioral Health Licensure to become a licensed professional counselor, or LPC. So this board's appointed by the governor with the advice and the consent of the Senate. These are people who are knowledgeable about counseling. They work in the industry typically. 4 of them are LPCs. 3 are licensed marriage and family therapists, LMFTs. 2 are licensed behavioral health practitioners, and 2 are representatives of the public with knowledge of counseling issues. So 4 members constitute a quorum. They serve for 3 years, and they meet 2 times a year, but no more than 4. And they are the ones that issue our licenses. So the first thing I'm just going to talk about is informed consent. We understand that we have to provide and inform clients about their rights, their ability to consent to their own treatment, their autonomy at the beginning of their therapy when it commences, and revisit it throughout the therapeutic process and remind them of this. Could possibly be a question. So we should also must also provide them with a copy of the Statement of Professional Disclosure. And then I just want to really quickly talk about confidentiality versus privilege. So confidentiality is what we use in the daily settings with our clients. Anything they tell us is kept confidential, and that's what we tell them. With the limits that we know of, which is harm to self and others, or mandated reporter for child abuse and elder abuse, and that imminent threats to others. That's not quite the same thing as privilege client communication. So privilege communication is a legal concept. So if the client is in a lawsuit, privileged information is their legal right not to disclose information that was in a counseling session. But there are also limits of that, and some of those are in the LPC Act document, but I just thought it was worth mentioning. The first might be client consent. If the client consents to releasing privileged information, or if they are deceased or disabled, a legal representative or heir can do that for them. If they are under 18 and were a victim of child abuse, there might be a requirement to testify. There might be disciplinary action, say for an LPC, who might be required to testify as to their own misconduct, criminal acts that have been disclosed, and also health and safety. And they can't prohibit LPC from testifying in matters of child abuse, adoption, etc. But we'll get into that about like forensic testimony and things like that. So once we apply to be LPCs, our application is valid for 2 years. Failure to essentially complete the application within 2 years, and those are all the necessary testing and components to initiate the application, it'll be voided. Once you pass your tests and start your supervision experience, for licensure, you have 60 months or 5 years to complete that. So we know that the academic requirements are a master's degree in counseling or a related field with at least 60 credit hours or 90 quarter credit hours, practicum and internship experience of 300 hours. They would like you to have coursework in all of the KCREP areas, and that is in the guide, the informal rules. I don't want to get into it now because it'll take up a lot of time, but essentially the variety of coursework that we had to take. Then once you have done that, you're going to need to fill out your applications. You're going to have to do your fingerprints, FBI check, OSBI check. I assume you've already done all that if you're here. So we will just pick up with this. So once you pass those exams, the NCE and the OLERE, and you have your supervision agreement, you can start your supervision process. The other thing is that there may be a time where an application might be denied due to fitness of the applicant. So criteria for the fitness of the applicant may delay or deny an application if they lack the skill or ability to be a counselor or a therapist, if they've misrepresented on an application or other materials submitted to the board, or if they've violated any of the LPC rules of professional conduct. So different materials used to consider and determine fitness might be evaluations from supervisors or instructors, statements from persons submitting references, evaluations from employees, professional associations. If it becomes an issue of an investigation, there could be field examinations, questions, interviews about the applicant's experience, documentation. Some materials used to determine fitness might be like allegation of clients from internship or practicum, transcripts and findings from official court hearings, investigations, or other pertinent information to determine fitness. So if there have been challenges with a person and their ability to act ethically and legally or just competently, then that can be challenged. So I want to talk about CEUs. So we know that CEUs are continuing education credits, and we have to have a lot of them. So when we originally get our license, it is good for 2 years. So in the first 2 years, the CEU, continuing education units, we need 40 clock hours for the first 2 years. So it's basically 20 a year. So clock hours is not the same as credit hours. Clock hours is the amount of time you spend on it. And we have to have 40 for the first 2 years. Typically, it's 20 per year, and at least 3 of those 20 must be on ethics, including the practice of counseling, treatment interventions, consulting and referral activities, or research activities. So that would be in the first 2 years, you would need 3 hours on ethics. So one graduate course credit hour is 15 clock hours, and one academic quarter credit hour is 10 clock hours. So this means that you could actually take master's level, graduate level courses in counseling or in related fields and have them count towards your CEUs. But so one graduate, so like a 3-hour course would be 45 hours. So a regular course would be 45 clock hours. So LPCs again, LPCSs, supervisors, must spend a minimum of 3 clock hours on supervision, including legal and ethical supervision, theoretical models of supervision, supervision intervention methods and modalities, and research in clinical supervision. Other ways to get CEUs are college courses, like I said, in-service trainings at your work or agencies, institutes, seminars, workshops, conferences, distance learning, home technology, affiliated content with the American Counseling Association, PsychWire, any place that can issue official CEUs. You have to have documentation required, the letter, basically a letter on the sponsoring presenter's letterhead, and you must retain your documentation of CEUs for 2 years. You can also get CEUs for teaching. So I can get 2 clock hours for every 1 hour of teaching. Too bad I'm not licensed yet. Or up to 10 clock hours total per year, but that's the first presentation only. So if I end up teaching this same thing 100 times, maybe it'll be smoother next time, then I would not be able to get hours past 10. So the State Board of Licensure will randomly audit 2 to 25% of LPCs on active status to ensure that their CEUs are reported accurately and with reputable places. So penalties for failure to submit CEUs by the date is that your license is suspended immediately and the rights are null and void until the requirement is fulfilled. LPCs have 12 months to complete the required CEUs and to pay the fee, the renewal fee, or your license expires. So there are fees associated with these applications, of course. So I'm going to kind of go over the fees, the renewal, and then situations where licenses may expire or be placed on inactive status. So the application fee is $145. The licensing fee, the exam fee, is $100. That initial licensing fee is $90 for 2 years. So on the anniversary date after 2 years, when you get your license, it will expire. Then you will renew your license and the fee will be prorated from the day it expires to end on June 30th. Misread. So it will go from the day it expires and it will renew on June 30th to get everyone on the same page. So every license in Oklahoma expires on June 30th. And then once everyone gets to June 30th, then it will renew for a full year, and then that is $80. So for example, if I get licensed in, let's say September 2026, that means my license will expire in September 2028, and then I'll renew it to June 30th, which I guess would be 2029, and then from there on, it will renew on June 30th every year. So I pay a prorated fee and also prorated CEUs. So the first full year after that renewal is $80. Late renewal fee is $25 plus the renewal fee. So it'd be 25 plus 80. Replacement fee for your license is $25 if you lose it or need to change your name. And your inactive license fee to reactivate it, if you've let it go inactive, is also $25. You can pay by check, money order, cash, personal check, or bank check. But if a personal check is returned, your license is suspended immediately until you resolve that issue. You can also pay possibly by debit or credit card. It said it just depends on what the board is willing to accept. So penalties and reasons the licenses may expire. So first of all, our license is issued by the committee. It has our name on it, our license number, and the date. It's signed by the chairman of the board, and it remains the property of the board. The renewal date is the last day of June, or the last day of the month, and whatever month you get licensed in, and then eventually June. It requires renewing compliance with all the rules, documentation of CEUs, and the fees, and this license must be displayed in the primary office in which the therapist practices. So by written request, your license can be placed on inactive status for $25, and this forfeits rights and privileges. So if you're not going to practice, you can place your license on inactive status, or if you're going out of the country, taking sabbatical. If you renew it within 1 year, you pay a fee and then the prorated CEUs for the year. So say you put it on inactive for 4 months and then you have 8 months left, you would pay the prorated 8 months and do a prorated hours of CEUs. After a year, you would do the CEUs for the year that was inactive and then the fee as well. So if your application is voided because you did not finish your supervision within 60 months, so 5 years, you can reapply. You include your application form, official transcript, application fee, criminal checks, so basically the whole process again, pass the NCE and OLERE again. Your practicum and internship hours earned in school do count. You don't have to redo those. However, your previous supervision hours do not count, and your previous exams do not count. So you will forfeit your hours if you do not complete them all within 60 months or 5 years. So application for application voided due to inactivity. So if you do the application, you get your fingerprints in and you're approved for all of your tests and you never take them, your application will expire after 24 months. So you can reapply as above. You have to redo the entire thing. Internship and practicum do count, but you will have to reapply with your official transcripts and all your fees and everything else. If for some reason your application is denied, for whatever reason, you can reapply, and that will include your application form, transcript, fee, criminal background checks, fingerprints, all that. You have to pass the OLERE and NCE again. Internship and practicum experience will carry over. Previous supervision will carry over, but you must do 500 additional hours. So this might be a situation where you make it all the way through your supervision experience and then something happened that when you applied for your final license, you were not seen to be ready. So what would happen there is that you would have to reapply, you would have to pass the tests again, but all of your hours will count. All of your internship experience will count, but it's been, I guess, determined that you need to do 500 additional hours of supervision. Okay, so now if you're a supervisor and your application has been revoked as a supervisor, if there's administrative action pending against you, you must wait 5 years to reapply, and then all of the previous requirements for becoming an LPCS apply. If your licensure application was denied because of a felony or any other kind of infraction, things like that, criminal, you have 15 days to request a hearing to discuss it further. Otherwise, if that hearing is not requested within 15 days, that denial of licensure application decision is considered final. And so I'm now going to spend quite a bit of time on supervision because there is a lot about it. So once we have our tests passed and we have our, application in and all that kind of stuff, we have to find a licensure supervisor. We have to practice again for 3,000 hours or 60 months, within 60 months, 5 years for licensure supervision. Full-time is at least 5 hours a week. So 1,000 of these hours have to be direct, so in the presence of a client offering therapy or group therapy, and then 2,000 would be considered indirect. 100 of those hours have to be in supervision with an LPC supervisor, so an LPCS, and that's at least 45 minutes one time a week. So 45 minutes one time a week. So the responsibility of supervisors and supervisees, so together jointly, we have to ensure that the requirements are met and fulfilled to be able to achieve our licensure. So if an LPCS fails to comply with the requirements, it could result in a loss of hours for us, denial of license for us, formal complaints, and a loss of supervisor status. So really, both LPCS and LPCC candidate have a lot to lose if we don't ensure those requirements are fulfilled. We also have to ensure our client's confidentiality is protected always, and the rules of the supervisee's employer are adhered to as well. So as far as like records, things like that, we have to maintain that. The supervisor has to maintain the records for at least 5 years after the counseling relationship, at least the supervisor-supervisee relationship ends or terminates. So even if it terminates before the supervision is up, the supervisor has to maintain those records. If it is terminated prematurely, the termination of supervised agreement form must be submitted within 3 days to the board. The supervisee is responsible for finding a new supervisor, negotiating the contract, and submitting new paperwork. So a supervisor, their qualifications, they have to be an approved clinical supervisor by a national board of certified counselors and familiar with the Oklahoma LPC Act. So that's if they are coming from another state, they would have to do all the transferring in requirements. Or they have to be a practicing LPC for 2 years, completing a graduate level course on clinical supervision of at least 45 contact hours. They have to be approved by the board. They have to have attended workshops in supervision and the study of literature in supervision. 15 of those 45 hours have to be in an in-person class, which includes at least 4 supervisors in training. The remaining 30 can be used for directed study. Have to pass the OLERE, must be on call 24/7 for the supervisee, or at least arrange for cover or someone else to take over if they're out of town. 3 hours per year minimum have to be spent on CEUs about supervision. And they cannot renew that LPCS until those CEUs are met. So issues with supervision and ethics of supervision, confidentiality, and all that have to be studied yearly and reinforced. If they don't meet those requirements, they will not be able to renew as an LPCS until the CEUs are met. According to that, if they are not met within 5 years, their license to be a supervisor will permanently expire and they must reapply fully. They can request it to be inactive in writing. They can reactivate it with the required CEUs. They can request to retire their license, but they may reapply. If their license was revoked for disciplinary action, they have to wait 5 years to reapply. They cannot have more than 12 supervisees at once. And if they want to petition the board, if they want to take more, they have to petition the board and provide a reason and demonstrate that they can handle it. So 1 or 2 years of supervised experience can actually be gained by essentially going back to grad school. You can have 1 year of supervised experience for 30 credit hours or 45 quarter credit hours beyond your master's degree related to a field of counseling that is acceptable to the board. However, if you decide to do your sort of supervised indirect hours that way, you still must do 1,000 direct hours under supervision with clients. When the applicant completes the requirements, they will continue working under supervision until they're fully licensed. Failure to complete your hours in 60 months or 5 years results in avoided application. Supervisors are to do at least 2 observations per year, so either lived or taped, and they will be part of the semi-annual evaluation that occurs every 6 months. Supervisors also have to consult with the LPC candidate's on-site supervisor if they're not the same as their licensure supervisor at least 1 time every 6 months. So again, the LPC supervisor and the LPC do not have to be the same person. The LPC supervisor does not have to work in the same place as the LPC candidate. So here are just some things on the kind of acceptability of the supervised experience. So just a lot of things to think about. Remember, supervised experience must consist of performance and counseling activities, kind of as described below. So they focus on basically the raw data from a practice that's available via observation, co-therapy, written clinical notes by the candidate, or recordings. So this is different than, say, psychotherapy sessions. The supervisor is not the candidate's therapist. Supervision serves by focusing on professional and occupational goals as well as client welfare. Supervision can be individual, which is face-to-face, one-on-one, or it can be group, where one supervisor can have between 2 to 6 candidates for group supervision. Supervision could be technology assisted via Zoom or other secure communications if it's board approved, and it must kind of be in consideration of like some type of physical or financial hardship, or barriers to being able to meet face to face, like distance, or if it's a specialty credentialing or things like that. So supervision starts after all the academic application items are complete. The LPC candidate must be an employee of a practice or an agency, not a contractor. They must always have an on-site supervisor accessible when they are seeing clients. And again, the LPCS does not need to work in the same location as their supervisee for licensure supervision. So documentation of supervised experience. Documentation is key. So they both will sign and submit the evaluation of the supervised experience form. It includes documentation of observation and date of consultation between the approved and on-site supervisors, semi-annually, so every 6 months, starting at the date of approval of the first agreement. So the document will include identifying information, time, place, and duration of supervision, the percentage of time spent in different counseling activities, such as group or individual, notes, things like that. Supervisor's rating of professional activity, a supervisor comment section, and then just a record of the supervised experience. So evaluation forms are submitted every 6 months. If they are submitted more than 60 days past that 6 month, they will not be accepted, and those hours for the previous 6 months will be forfeited. So those forms must be in as soon as possible after that 6 months. Supervision hours are recorded in quarter credit hours, so on the 15 minutes. So just more for supervision, just some other things. Supervisors are not allowed to engage in sexual conduct with supervisees. They can't supervise someone they've had sexual relations with within the last 5 years. They can't engage in sexual conduct with anyone they have ever supervised within the last 5 years. They are not to exploit the trust and dependency of supervisees. They're cognizant that this is a potentially influential position that they have, and they should not exploit the trust of their supervisees. So they should avoid dual relationships that can impair professional judgment. So no going to the bars with your supervisor, where they will all of a sudden realize you're not very professional because you can dance on a table. You know what I mean? So don't allow supervisees to perform or hold out services beyond their scope of competence, or to hold out that they are competent in something that they're not. LPC supervisors do not disclose LPC competence to anyone except required by law in case of imminent danger, or if the LPC is subject to legal action from supervision that requires, again, privileged information to be disclosed, or they have a waiver in writing. So LPCSs must disclose or must maintain that client confidentiality with their supervisees. We also have a little bit about, say, forensic services. So LPCs may be asked to perform forensic services, which kind of include but not are not limited to, say, assessments, interviews, consultations, custody evaluations, reports, expert testimony. These results are intended to be delivered to people who make decisions in these cases. The LPC must be competent, in the area that they're evaluating. Their information and their findings must be gained through lawful and ethical means. If they, say, have to interview a minor child for custody hearings or things like that, both parents must consent. This is typically fact testimony, not opinions or recommendations. So the LPC is kind of neutral and not recommends in this case. So the other thing I'll talk about is the complaint process. The RFI, request for inquiry, violations typically are reported in 30 days. So essentially, if one LPC or LPCS witnesses a potential violation of the rules, say they know that someone is practicing beyond their scope, or they know that someone violated confidentiality, or they know someone had sex with their client, or there's a dual relationship, they have 30 days to report either a written or oral statement of a complaint from anyone, to anyone, or alleging the violation about anyone. Anyone can file this. The complaint committee is made up of the executive director, who has the authority to respond directly to a complaint if the allegation doesn't seem by their determination to violate any of the rules, or it's actually referred to the full complaint committee if it does seem to violate the counselor rules, the LPC Act rules. So the committee can meet and they can appoint an investigator. They can authorize a formal complaint process and notice of hearing. If there is an emergency, if they're finding that LPC is putting a client in imminent danger, they can issue a summary suspension. They can end up with the Assistant Attorney General for legal proceedings, according to the proceedings by the APA. There's a maximum of a $10,000 fine for any of these things. The request for inquiry, when I say that, and the identification of the complaint is confidential, and it's not available for public inspection. So there are a lot of fees associated with being an LPC. We might have talked about them already, but just again, that application fee $145, maximum fee $10,000, specialty designation fees $50, specialty application $100. One thing to think about is that military personnel who are therapists in active duty, they have their fees waived. They also are able to have expedited processing for spouses if they move here, and their spouses' fees are waived. So there are a lot of considerations for active duty military that might come up on the exam. And now I'm just going to kind of skim through some of the other things that might come up on the test. I didn't really talk about sort of the actual rules or things like that as far as like what they can or can't do in the specifics. So for example, some of these rules are a little bit different than the what the American Counseling Association would say. For example, the first one that is different from the American Counseling Association is that the ACA says that you cannot have, say, like sexual relations with a client, a current client, yes, but if they're your former client, you have to wait 5 years. Whereas the Oklahoma rules say never. So never, never. The other thing that's different between the ACA and the Oklahoma rules is bartering. So the ACA allows you to barter for services, but the Oklahoma rules do not. So in Oklahoma, you can only barter for goods, and they have to be goods at fair market value, and only if the client requests it, and sort of if it's an acceptable practice. Dual relationships, which is where the LPC might be say, friends with someone or know someone from church or things like that. So LPC shall not knowingly enter into dual relationships in Oklahoma and just take the necessary precautions to prevent them. If they've inadvertently entered a dual relationship, they have to put it in the records and then take reasonable steps to eliminate it, or eliminate the source of it, or the agent causing the dual relationship. Oklahoma does also recognize small towns, and sometimes those relationships cannot be prevented or eliminated. You can't refer the client to somewhere else. So you have to try and do what is necessary to say, like, prevent the exploitation of the client or the impairment of the LPC's judgment. So you would have to document the circumstances of the dual relationship, secure the client's written consent to continue, and then consult with other professionals or supervisor to talk about the risks and impairment. We're not supposed to counsel clients to whom we've had either prior associations or any sexual contact, close social, financial, professional, personal, non-therapeutic relationship with clients, or engage with people who would interfere that. We can't have a knowingly say enter into interactions or personal friendships with former clients for 5 years after the termination of the counseling relationship. We can never once again have sex with our former clients. It says it so many times. We're not supposed to invade their privacy. We're not supposed to like ask them questions that aren't reasonable in the counseling process. So don't just make inquiries or matters that they say that are not reasonably calculated. We are not supposed to misrepresent our credentials. We cannot use the term doctor unless our doctorate degree is in a field of psychology or closely related to counseling from an accredited university, things like that. So if I'm a doctor of petroleum engineering, I cannot call myself Dr. Nicole. So the doctorate would have to be in a field like that. One of the most important things is referring. If we determine we're unable to be of professional assistance to a client, we should not enter that counseling relationship, but we must refer the client. We cannot leave a client hanging. We can't abandon or neglect them without making reasonable arrangements for the continuation of care. If we become cognizant of a disability or a condition which might impede or undermine or interfere with our duty of responsibility to our current clients, if we have a bias or anything like that, we need to take the steps to likely terminate the counseling relationship. Maybe so much with a bias, we have to seek supervision always, and then do what we can to protect the client. So if we are emotionally, mentally, physically compromised, we need to act in the best care of the client and take steps to terminate the relationship and refer. We cannot render professional services under the influence of drugs or alcohol. We cannot have sex with our clients. And we will, once again, not claim credentials or specialties beyond what we can do. So if we want to have a specialty designation, we have to take steps through the board and through the proper education to have that specialty designation, which the board will approve. I think that might be it. 40 minutes almost of me talking. Hopefully this has been helpful to at least review some of the highlights. There's so much in these documents. 41 pages, not 60, but still quite a bit. I guess if you include the other ones, it is more. So anyway, I hope this helps. Good luck on your journey through licensure. And thank you for listening.